For 230 years, dating to the founding, states have always held seats in the House according to the number of persons in each state, without regard to immigration status. Now, with respect to standing, the test under Susan B. Anthony is whether there is a substantial risk of injury. And past experience shows that it's easy to risk changing the apportionment. In Utah versus Evans, according to the party's summary judgment briefs, the practice of imputation added a total of 32,000 people in North Carolina and 5,000 in Utah. And that difference was enough to shift one seat from the latter to the former. We know that the numbers here are much bigger. As Justice Kagan pointed out, the government has information on millions of undocumented immigrants. And 1.5 years ago, when the president issued an executive order in July of 2019, he stated that the government could already match citizenship records for 90% of the population. So there's a substantial risk of injury now, and it would be better to resolve this issue now rather than in 6 months during the redistricting process, which could be disruptive.
Mr. Ho, what is the problem with post-apportionment litigation? Right now, as the questions have shown, we don't know what the secretary is going to do. We don't know what the president is going to do. We don't know how many aliens will be excluded. We don't know what the effect of that will be on apportionment. All these questions would be resolved if we wait until the apportionment takes place. So why aren't we better advised to do that?
Well, I think waiting a couple of weeks wouldn't be very disruptive, Mr. Chief Justice, but the record establishes that there's at least a substantial risk of a shift in the apportionment now, which is enough for standing. And if the question is, should the court wait now or send this back for another round of expedited proceedings, then there are many good reasons to decide this case now. The government argued that waiting would deprive the nation of prompt notice of reapportionment as required by statute, and that it could be very disruptive to redistricting processes in a number of states.
Well, waiting a couple of weeks isn't going to give us much more information than we have now. Waiting until apportionment will give us all that information that we don't have.
Oh, I'm sorry, Mr. Chief Justice. I did mean waiting the 4 weeks or so, maybe 4.5 or 5 weeks, depending upon when the apportionment report is delivered, to see what those numbers look like. I'd agree that that short of a wait wouldn't be disruptive. But if we're talking about sending this case back for additional proceedings in the district court, another expedited appeal, and doing this all over again over a period of several months, then that would be, I think, disruptive to ongoing redistricting processes.
Thank you, counsel. Justice Thomas?
Yes, thank you, Mr. Chief Justice. Mr. Ho, if the additional information would be beneficial in a few weeks, wouldn't it be beneficial to actually resolving this case? As the questioning seems to suggest, there's some difficulty in assessing exactly what information will be available and what that information will be.
Well, Justice Thomas, the challenge here is to a policy that broadly mandates the exclusion of undocumented immigrants to the maximum extent under law. And the government's position is that under law, all undocumented immigrants may be excluded. As Solicitor General Walz noted, their view is that the entire category of undocumented immigrants are not inhabitants. So the court is presented with a facial challenge to a categorical policy. The government's been free to issue a narrower memorandum excluding one or more subgroups as purported non-residents rather than taking aim at undocumented immigrants writ large, and it hasn't done that. It's the categorical policy that's at issue, and it's unlawful.
Well, I think your argument would be that the implementation of a categorical policy would be unlawful. But what I'm hearing is that we don't exactly know which category or subcategory will be excluded.
Well, as I take Solicitor General Walz's representations here, it's that the government will exclude to the maximum extent that's feasible and that's permitted under law. And the government's view is that the entire category of undocumented immigrants may be excluded under law. Even if we take the government's 3 proposed subcategories of undocumented immigrants who are supposedly per se excludable, those categories are quite heterogeneous. They're overbroad. I don't think that they are all categorically non-inhabitants.
Thank you.
Justice Breyer?
Thank you. What do you think about excluding the lawfulness of excluding just the 50,000 or so who are in ICE centers or under final order to remove?
Well, Justice Breyer, the population of people in ICE detention, as I noted, is quite heterogeneous. Even under the government's definition of inhabitant, many of those people would qualify. You can be a lawful permanent resident and be in ICE detention. Even a person who is, say, detained at the border, that person can apply for asylum. In some years, more than half of asylum claims.
Well, suppose you would change it slightly and say, we are going to exclude, not count people who are under legal order to remove.
Well, people under final orders of removal can actually reside in the country for quite a long time. They can petition for review to courts of appeals. They can seek other forms of relief. They can challenge their orders collaterally. Some are never actually deported, even after going through all of those processes, because their home country.
All right. So what line would you draw between those whom they could legally deport, not count, and those whom they can't?
Well, the constitutional standard, as this court explained in Franklin, is usual residence. And the plain meaning of that term turns on whether or not someone commonly resides in the United States. It doesn't turn on their lawful immigration status. That term, usual residence, was defined at the founding as where a person commonly lives or sleeps. That's in both the Johnson and the Bailey dictionaries that we cite. And if you look at the dictionary that the government relies on, Webster's 1828, which they rely on for the definition of inhabitant, it defines residence as distinct from nationality, offering the example of the residence of an American in France or Italy for a year. So residence doesn't admit of exclusions on the basis of lawful immigration status. It turns on whether a person's physical presence is transient or not.
Justice Alito?
I'm going to try to see if I can get you to answer Justice Breyer's question. Last term, we had a case involving an alien, Mr. Therasagium, who crossed the border unlawfully and was almost immediately apprehended and then placed in detention. Would he have to be counted?
Well, under the Bureau's current residence rules, he would. But I just would note that the court's holding in Therasagium, was about whether or not someone had entered for purposes of...
No, I understand that. So is it your position that every single person every single alien who is in the United States on Census Day must be counted?
I would say that every person who is an alien in the United States on Census Day is subject to the same residence requirements as anyone else who is a person inside of a state. If a United States citizen is usually a resident abroad and is temporarily visiting the country on April 1st on Census Day to see family or something like that, that person's not counted in the census. I think the same...
Well, you're saying that for each of these people there has to be a very fact-specific determination about whether they are a resident or not? Is that administrable at all?
Well, the rules that were administered by the federal marshals in the first census in 1790, Justice Alito, were to ask whether or not a person usually resides at the dwelling that's being visited. If not, where do they actually usually reside? And if the person has no stable residence, to count them simply where they're found on April 1st. That's been the practice since the founding. But I would agree, I just want to make clear, I would agree that there is discretion to make decisions on the basis of residence. But the plain language of the operative constitutional and statutory provisions don't turn on lawful immigration status. They turn on the facticity of a person's residential circumstances.
Thank you.
Mr. Ho, I'd like to follow up on the effect of waiting in this case. Is the waiting problem that the census apportionment doesn't happen till April 1st? Is that correct?
No, Justice Sotomayor. The Commerce Secretary's report is due to the President on December 31st, and then the President must submit a report to Congress within 7 days of the beginning of Congress's term. That's either on January 10th or 11th, and then the Clerk of the House must, within 15 days of that, send certificates to each of the states notifying them how many seats in Congress each state will get. So we're talking about...
So the apportionment already begins once the report is issued. And so we would have to unscramble the egg.
I think that's right.
All right. Now, can we go back to the question that seems to be at the nub of what many of my colleagues are asking about, which is, can and should we rule that simply that not counting illegal aliens because they're undocumented, that is a violation of the statute and the Constitution? Is that enough relief to you?
I think it is, Justice Sotomayor, because the policy that we're challenging is broad and unequivocal. We're bringing a facial challenge to it, and the policy lacks a plainly legitimate sweep. The vast majority of undocumented immigrants qualify as usual residents under any plausible interpretation of that term. 66.
Assume I even agree with that, however. Would that just mean, what does that mean practically? What does the Secretary do? He doesn't send anything? How about if the President comes back and says, just send it to me on these categories? What happens then?
Well, the injunction prohibits merely the inclusion of information to implement the existing presidential memorandum in the Secretary's 141 report for apportionment. It's not a gag order on the Commerce Secretary. There's nothing that would prohibit the Commerce Secretary from publishing various counts of subcategories of undocumented immigrants on the Internet. That's not something that's prohibited by the injunction.
Justice Kagan?
Mr. Ho, I guess I would like you to comment on General Wall's view of the feasibility of the matching process. Whether you have any insight into that, into how the process works, and maybe as part of that, whether you have any insight into the question of why it is that the government knows now that it can do that matching with respect to the ICE detainees, but isn't sure it can do that matching with respect to categories of people for whom it has equally good administrative records.
Well, Justice Kagan, I'm not a social scientist, but here's what I know. In July of 2019, the President issued an executive order on the collection of administrative records as they relate to citizenship, with one of the goals being to ascertain the number of undocumented immigrants in each state. And the text of that memorandum states that the Census Bureau, at that time, this was in July of 2019, so about a year and a half ago, the Census Bureau had determined, based on experience, that administrative records to which it already had access would enable it to determine citizenship status for approximately 90% of the population. So we know that the Bureau has a lot of experience with matching. It can do it for the vast majority of the population already. That's with administrative records maintained by the Social Security Administration and other executive branch agencies. They've been collecting more records for the last year and a half, and as Your Honor noted, the government has information on millions of undocumented immigrants. I think when you add all of that together, that's at least a substantial risk of injury, because it doesn't take much to change the apportionment. As Justice Breyer noted in his opinion last year in the citizenship question case, the difference of a few thousand people in a state can mean the difference between gaining or losing a seat.
Thank you, Mr. Ho.
Justice Gorsuch?
Thank you, Chief. No questions.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Mr. Ho. First, I want to make one point in response to something General Underwood said, and I'm hoping the Solicitor General can address this on reply about the declaratory judgment after apportionment, who that would be addressed to, and how that would work. That's something that I would appreciate more from the Solicitor General on, but not going to be able to ask at that point. As to you, I want to ask you about your point that we should rule now because the memo expresses the intent to exclude non-citizens who are here unlawfully to the maximum extent under law, is what you said, and you quoted that a couple times. You also referenced, I think this is important, the memorandum says feasible, and I think the argument is revealed, as did the briefs, but the argument even more clearly, it's going to be very difficult not going to be particularly feasible to exclude all of the non-citizens. We're going to be left with categories. How do we think about feasibility?
Well, the government's identified three subcategories of undocumented immigrants, which in the last few pages of their reply brief. So I assume those are the ones that the government thinks are the most feasible. But each of those groups, I think, is overbroad. Those groups are heterogeneous, and to exclude any of them would violate constitutional and statutory commands. There's people detained at the border, but as I mentioned, a lot of people.
But I'm sorry to interrupt, but could we rule to that effect now? We really haven't had briefing and argument on the particular subcategories.
I'd agree that to the extent the government wants to rely on saving this policy with respect, by citing one or two purportedly valid subcategories to exclude, it would be better for this court to get full briefing on those categories. But there's nothing that stops this court from ruling on the facial validity of this policy, because it plainly lacks a legitimate sweep. It applies broadly.
And then in litigation in January, we would deal with the subcategories. Is that how you foresee this?
If that's what the president ultimately ends up doing and issues a new memorandum, I think that would be something that, we'd have to deal with one way or another, because the injunction in this case that was issued by the district court doesn't prohibit the exclusion of particular subcategories under a different memo than the blanket categorical one that's at issue in this case.
Thank you.
Justice Barrett?
Mr. Ho, do you agree that there would be nothing wrong, or there would be no legal prohibition against the president issuing a new memo articulating a new basis for excluding subcategories?
Well, the injunction in this case doesn't so preclude the president, Justice Barrett. I don't know if I would commit to there being nothing wrong or it being not being unlawful. I think we would have to see what the memo does. If it excludes people on the basis of transient residence within the realm of the president's discretion as his court.
Let me just clarify. I didn't mean that the lawfulness of whatever the new memorandum said would be determined. I just meant that there would be nothing unlawful about his switching positions and articulating a new rationale for why certain categories of illegal aliens were excluded.
In that hypothetical, Justice Barrett, it wouldn't just be a new rationale. It would be an entirely new policy with a different scope in addition to different reasoning. So
but he could do that, right?
The injunction in this case doesn't prohibit that. That's right. Now, whether or not that particular policy would be lawful, I think, would be
a different question. As you told Justice Kavanaugh, that would be a bridge we would have to cross later, right? Like if he said, listen, it's just not feasible, we haven't been able to get the information, so this is why we're going to exclude those in ICE detention facilities, say.
Well, if the reason were simply feasibility, but the basis for exclusion were that they were undocumented and their lack of lawful status, then I think that would run into the same kind of reasoning that this court pointed to in Shelby County.
Right, excuse me, Mr. Ho, but in that instance, you're saying that the policy itself would be unlawful, but you're not taking the position that he is precluded at this point from changing positions and issuing a new policy, the lawfulness of which would be a separate question.
Yes, of course, that's right, Justice Barrett, because the injunction below, is specific to the policy that's been issued and its categorical nature.
Thank you, Mr. Ho.
A minute to wrap up, Mr. Ho.
In closing, Your Honors, no court, no Congress, and no executive branch before now has ever thought that undocumented immigrants could be excluded from the whole number of persons in each state. In 1868, the 14th Amendment based apportionment on persons, not citizens, specifically to embrace the entire immigrant population and to secure ratification by states with large immigrant populations. And in 1929, Congress mandated apportionment on total population, the plain meaning of which does not permit exclusions for immigration status. While the president may have some discretion in borderline cases, he does not have authority to erase millions of state residents from the apportionment based solely on unlawful immigration status. As the Latino Justice amicus brief notes, undocumented immigrants contribute $1 trillion in GDP, $20 billion in federal taxes, 80% are essential workers, 1 in 4 are homeowners and pay property taxes. They're our neighbors, our co-workers, and our family members. They are usual residents under any plausible definition of that term.
Thank you, counsel. Rebuttal, General Wall.
Thank you, Mr. Chief Justice. So as I think Appley's response is confirmed, there's no